Love and Law episode 23. Today we are going to discuss a topic that it seems to be a little bit unclear.
Although we've discussed it several times.
Legitimation. I don't know where the miss is or where the misinterpretation or the disconnect is, but hopefully we can get some clarity this go round.
I suppose, legitimation is obtained differently in different states. And so we're going to address Georgia because that's where we are. That's where our firm is. That's where we're based. That's where I am licensed. In Georgia, if a man is not married to the mother of his child when that child is born, he does not have legal access to the child. You have to get your child legitimized through the courts. And signing the birth certificate doesn't do it. Being put on court-ordered child support from the child support office doesn't do it. You have to file a petition to legitimize the child. So you go to court, legitimize the child. Or you have to be married to the mother, or marrying the mother after the child is born will legitimize the child as well. So it's one of three ways. Be married when the child is born, get married after the child is born, or go to court and file a petition for legitimation. And that legitimation allows you to have access. So I'm just giving you the ground rules so you understand the definitions before we really dig into the fights that Charles and I have about the access that people have to their children. But people need to be clear that legitimation only speaks to your right to inherit. If you were to die without a will and you and I were not married, our son would not be a legitimate heir of yours. And so the state would not recognize him unless he was in your will by name. So if you die without a will and everything goes to your children, he would not be considered one of your children because he's not legitimized. Unless you say, I leave X to, and you name the child birthday or some ways that you clarify him specifically in that will. If he's not named in the will, he would not be considered your heir. So legitimizing your child lets the world know legally that this is your child. It has nothing to do with custody at all.
So if you just, I guess, the follow-up question.
Mm-hmm.
Let's say that you have a illegitimate child, but you have a will. The children that are legitimized are the ones that you were married and had. And the one that may be the outside looking in, if you had a will naming him to specific things of yours, would that will stand or could
Yes, but I don't want to get into semantics of wills because I'm not a will, trust, or estate attorney. However, anybody you name in a will by name, whether you leave something to your next door neighbor, your third grade teacher, or your Uncle Fred, if you name a person in the will and leave them something, they're fine. And your child that is not legitimated falls into that category as just being a named person that you left something in the will. So that would protect the child. But if you're looking for custody and access to your child, you have to first legally claim the child, which is why you legitimize the child and then file for joint custody or sole custody or visitation or whatever we're going to go forward with. In Georgia, most family law attorneys do that in the same petition, a petition for legitimation, custody, parenting time, and child support. It's all done in one petition at one time, the same time, generally. But I just wanted to explain when people say, I want to legitimize my child, what I believe they're meaning to say is that they want to legitimize and also gain custody and parenting rights to their child. So I get a lot of very angry comments in social media as if I wrote the laws, and I'm just making sure that you know what they are. In some states, signing the birth certificate will legitimize the child. In Georgia, again, that is not the case. And I don't know if that's going to change or when it's going to change. I am a huge proponent of requiring DNA tests if the couple is not married. And I think they should do it at the hospital when the child is born. And if the person is the father, then they should sign the birth certificate. Those tests can come back within, a day or two at the hospital. And that way, the father knows for sure that he's the father, the mother is clear, the father is clear, and the dad can start bonding with the child immediately. Now, that's just my personal opinion, just because of what I've seen in family law. And there's so many miscalculations on gestational periods, and if you're the father, if you're not the father, and all that stuff, and hearts are broken and attachments are made. And then when people break up and you find out it's not your child, it's not always so easy to undo if you have already held the child out to be your child, or if you signed and went and did legitimation and decided not to do the DNA test. Just so many things come into play with that. But there should be some way to make legitimation easier for fathers so that they have access to their children sooner. I do believe that.
Agreed. What that way is, I don't necessarily have a idea. The testing at the hospital sounds like a reasonable idea, but I'm sure there's going to be some cons to that as well.
Like what?
The fathers that thought that the baby was there and it turns out not to be.
So how would that be a negative? If you,
It would be a positive, I guess, because you find out the truth. But the surprise, shock, and all, depending on what you've had invested and what you thought the relationship was, you thought that.
That's two different things. You're what you think the relationship is. I'm more concerned about whether the child is the child of that man, and so that the child knows who the father is, can have the love and affection of the father
From day one.
From day one. So how it affects your relationship, they need to deal with their relationship. But as it relates to the child, let's get these things sorted up front. Or if the man is 100% clear, it's my child and I want to waive that, there should be some form that he should be able to legitimize the child, not just legitimize the child, but legitimize the child and therefore gain 50-50 custody. And I think that's going to be very controversial for a lot of people. But if he is found to be the father, I think that mom and dad should have equal access to the children sooner. A lot of men wait to do this legitimation thing after mom and dad are arguing and they've broken up, and now we want to go to court and argue. And far too many times this occurs when the child is school age or 6 or 7 years old and have developed a relationship. Mom and dad can break up when the baby is 3. But they piece it together and they're fine because he's not in a new relationship or she's not in a new relationship. But as soon as the boat gets rocked, now we find ourselves in court. And now it's the time that everybody wants to fight and argue and say, I want custody or I want to change this. And then we have this legitimation, paternity, custody, parenting time battle that starts after the breakup. And it creates a lot more turmoil for the children and the people involved. You and I have had several arguments back and forth about the access that men have to their children, how they should have their children, and I think it's grounded in what you set up from the beginning and having that line of stability for the child from the beginning. Not mom, not dad, not equal rights to the child. If you have a child that is, let's say, 5 years old, and the child has lived primarily with the mother, and now then mom puts dad on child support, and now dad wants to file for legitimation. Now and only now you want to file for legitimation and joint custody. That's going to be a problem. And it's not a problem because women have all the rights. It's a problem because, and when I say problem, it's going to be a problem with him getting 50-50 or somehow asking for custody. And it's not because the courts are set up for the women. It is because the child has developed a routine. The child has a school and friends and so on and so forth. And if the dad is not consistent in that, the courts should be looking at what's in the best interest of the child. And a young child needs stability. The back and forth is not what's best for the child. And a lot of men get upset by that when you want to petition the court when the child is 5, 7, 10, 11 years old.
So if he
And
does
now
that
you're talking
before,
about 50-50.
so if he does that before the child starts school, then is that still a problem?
Well, it depends. It's not. There's no cookie cutter. That's what I'm saying. It depends on individually on the child. These parenting plans are as unique as the children that are being discussed. If you have parents that live an hour apart from each other, 50-50 custody is not going to be what's best for the child in most cases. People, all your comments about, it's my child, it is your child. I'm just telling you my legal advice from having seen this hundreds of times over some 20 years. If your child lives an hour away, trying to do 50-50 custody so that you feel fair instead of inconveniencing the child, consider moving closer to the child so that you can also get the child to school and the child's not getting up in the morning with an hour commute in the morning to get to school so that you can have 50-50 custody. If it's that important to you, move closer to where the child is. That's just one option.
That helps, but that doesn't guarantee the 50-50, though.
It doesn't. Nothing guarantees 50-50. But I'm just saying, if you don't live close to the child, 50-50 is almost a non-starter as far as an option. If you are an hour away from the child and the child is obviously got to go to school and the child got to be to school at, our son, school started at 7:55 in the morning. So you're going to get up in the morning and drive through Atlanta traffic and try to hope that he's on time. If you're leaving, giving yourself an extra 20-minute grace period for traffic because it happens, you're talking about it's just unreasonable and unfair for the child to get up an hour early, hour and 15 minutes earlier than the normal time so that you can drive them back and forth. And then after school, back and forth. And all of that is just unnecessary. And men get upset and feel like they're getting the short end of the stick. And it's not the short end of the stick. It's just that the child has to be considered first. And if the mom has been the one there taking care of the child since the child was born, and the mom has a routine where the child goes to this daycare, and the child has this room, and the child has this, and everything is set up, and the child sees you when it's convenient to you, then most courts are going to say, we're going to set up a parenting plan that speaks to when it's still convenient to you, like every other weekend. There are other scenarios where you have fathers who are very, very involved, and a lot of them get primary custody. Or you have fathers that are very involved and they live close enough that they do week on, week off. Or they do a 5-day weekend every other week. And every Tuesday pick up from school overnight or something. They're just more involved because that's the father they were before the breakup. But if you weren't that father before the breakup, don't expect the court to give you that time simply because now you're in court and now you feel you have some entitlement to some 50-50 custody because now you decided to legitimate your child and you decided to go and get parenting time and get something on paper. But if you haven't lived that life since the child was born, it is going to be, and rightfully so, very difficult for you to walk into court and try to demand that time because we're not together now.
I guess when you say that father before the breakup, what do you mean the father before the breakup?
If you weren't splitting parenting responsibilities with the child before the breakup or before the court date, for instance, if you and I were to break up and we weren't married and we have a, let's say, 7-year-old child, we break up when the child is 3, and this is a case that we recently have. That's why I'm saying this because it's fresh in my mind. They broke up when the child was 3, and mom and dad argued back and forth for the last roughly 4 years, arguing about child support, arguing about who's going to have the child, back and forth, whatever. Mom decided to put dad on child support through the child support office, and his response was to seek legitimation, and now he wants 50-50 custody. Now, they were together, living in the same house until the child was 3. But for the last 4 years, which means kindergarten, first grade, second grade, they have lived about an hour and a half away. How are we going to do 50-50 custody? Even if he moved next door, and in the last 4 years of the child's life, you've seen the child on average 1 weekend a month, according to him. How disruptive would that be for that 7-year-old child to now live week on, week off with someone that you have seen, according to him, maybe about one weekend a month.
So what was his reasoning for the legitimation in the 50-50?
If I gotta pay for it, I might as well have joint custody. Might as well have joint custody since now since I'm gonna be on papers anyway. I was trying to work it out with her. She's not being reasonable, and I think that mom was getting frustrated because dad was inconsistent with financial support, and so she was withholding the child, which is absolutely wrong. And so she's frustrated about not getting the financial support that she thinks she deserves. And he's frustrated and not giving her money because he feels like he doesn't have access to his children. And so they're both frustrated. And so since she involved the court, he wanted to also involve the court. And now the court is involved, trying to figure out what to do. He has no intentions on moving closer to the child. Another example of a situation. I'm talking to a dad who has not physically seen his daughter in 4 years. He talked to her occasionally. He hasn't physically seen her in 4 years. And he shared with me that he's building a house. And he can't wait till he builds his house, and then he gonna go get his daughter because, he wants to do 50-50 custody, or he wants to jump back in and establish some parenting time because she's 10, and before they broke up, we lived together in this big house and so on and so forth. They've broken up, bad breakup. He has not seen her in 4 years. He talked to her on the phone, and he talked to her. He's literally have not FaceTimed her and seen her face. He's seen pictures of her. And I had a very hard, serious conversation with him. He has an uphill battle to go into court and say, I know I have not, and mom has sole custody. They did go to court. He did legitimize her, and mom got sole custody.
And how old is she?
The baby's 10 now. But you want to modify custody. And you want to and the only reason mom had sole custody because he moved out of town. That was part of the breakup. He was out of state. My point is, he's been back here, and he has not seen the child, physically has not seen the child in 4 years. And to go into court now and assume that you're going to get, and he's like, but we don't even, the house I'm building, we're not even 5 minutes away from each other. But you haven't seen her in 4 years.
But you said the mom wasn't allowing that.
You're mixing up the two stories. In this situation, this man has not seen this little girl in 4 years. He drives trucks. He's gone a lot. He talked to her on the phone a lot. He has not seen her in 4 years because they had a bad breakup. But to step back in with a child you have not seen in 4 years and think that because you build a house, and he was so proud of the house he built and so on and so forth, that baby don't give a damn about no new house and no 2 stories and no this and that and the amenities in your neighborhood. She has not seen you in 4 years. And you think that she's going to just, oh, yep, I'm just going to, come live with you week on, week off because you have a big, pretty house that's close to the house that I've grown up in my whole life. It's just unreasonable. Why wean your way back in? And you're not even talking about.
But you said he's been talking to her, so that's not weaning himself in.
4 years. So you think there's adequate parenting to talk to a child for 4 years to talk to her?
I have a lot. I have more questions of why.
What are your questions?
Why didn't you see her the 4 years, and what is regularly talking to her? I mean, was it a situation that I don't know what the circumstances were that you only had phone communication, and then even if there is a weaning in process, okay, well, we start off with once or twice a month and then build up to that. I wouldn't have an issue with building up to it, but you have to start somewhere.
I'm not saying that we're not going to start somewhere, and I'm not saying that if I was the mother that I would be opposed to y'all having in-person time. Don't have a problem with that at all. But week on, week off probably wouldn't even be anything that I would consider. She's 10. And for me, the routines and everything has been set, and especially if she's thriving and doing well, we could do something else. It wouldn't be week on, week off. It just wouldn't be a thing. It wouldn't be an option for me. I don't think that would be what's best for that child at 10 years old in 4th grade and kindergarten through 4th grade. She has a routine. She's well. She's doing well, healthy, mentally, educationally, spiritually. She's doing well in your absence. And so now that you have your nice new house and it's convenient to you, now you want to come back in and do that. The phone calls that you've been having, I hope they improve and transition from phone calls to visits. Visits,
So
that's
you've just
fine.
been missing for the last 10 years out of state, and now
I
you
said 4.
4 years.
Hmm.
Okay, well, what went on the previous 6?
They were together. They were together as a couple.
So it's 4. So he's been absent for 4 years.
They were together. He was a long distance truck driver. The relationship ended badly. And the last 4 years since the relationship ended badly, I don't want to deal with her. And so I just left and I call and talk to my children. So you don't have to deal with her. They have a son that's older, that's 14. You talk to him, you see him, but you meet him out in the street and pick him up here and there. You just don't want to be bothered with the mom. And so you're not going to go through the headache of being bothered with the mother. And so you just don't see the child. And your plan is to just wait till she get older like you did with your son and then catch her when she get older.
I remember this one now that you're saying it, and there are some things that I thought was a little different. I don't know if they're being left out for other reasons, but
No, you actually don't remember this one. This is somebody that I spoke to also on yesterday.
yesterday,
And so you're very,
very clear. Remember.
Okay.
So I he's attempting to, regardless, reconcile that relationship. Whether it's 50-50, there needs to be a starting point. I understand and see your point of the week on, week off. The timing of that isn't right now. You need to build up to that if that eventually gets to that. But in the meantime, he should have some access to his daughter, whether it's the standard weekends or something. I think that he should be given the opportunity to be involved, especially if he wants to be involved.
I agree with that. But that's what I told him. That's what I told him. You need to go to court and do that. And this whole, we're going to talk about it, we're going to figure it out. 4 years has gone by. My point, bringing it all the way back full circle, is that when you have a child and you don't have legal access to them, you need to go through the courts and get legal access and get a parenting plan and get joint custody so that these breakups don't disrupt your ability to parent your child. That was my point from the beginning. Because people wait till they have these terrible breakups and then you need time to vent from the other parent, but the child is missing in between. And then when dads circle back around, now that people's feelings have subsided, the child has been left flailing in the years in between until things got to a place financially or emotionally or physically that you can kind of pick back up. And all I'm saying is it's not fair to the child and it's not usually in the child's best interest. And so the courts will decline to give the fathers the time that they're seeking when there have been, if there have been long gaps.
So it's a question. How do you suggest that the people that are still together, that are not married, the relationship is reasonable, how do you suggest those people go about legitimizing their child and not ruffling the waters? Because there are people that call and the couples are still together and the father's like, well, yeah, I want to legitimize my child, but I'm kind of, I don't want to rock the boat or it may create some issues that aren't there. How do you suggest those fathers move?
And see, in those situations, I think that it's a lack of knowledge. I think it's a fear of not knowing what will happen, and that fear largely is on both sides. The mothers feel like and a lot of times, not every time, but a lot of the women feel like the father is trying to take their child away from them, or they use it as well, we don't have to do that. We could just get married. If we get married, you have custody. And a lot of the men we talk to, they don't want to I'm not ready to get married, but I want to have equal rights to our children. That's one. So that fear from the women of not wanting to lose custody or feeling like you want to go to court and get joint custody so that you can have access to the child, but you don't want to marry me, which will also give you access to the child and unite our family. So that's a friction that happens a lot when the fathers are going to the mothers that are pregnant or just had a baby and said, let's go to court and get joint custody this way instead of getting married. The men that I talk to oftentimes have fear of, if I do that, she's going to want to put me on child support, and they don't want to be put on court ordered child support, because the stigma and fear attached to court ordered child support has shaken so many men to their core that they just don't do the legitimation while they're still in a relationship for fear of being put on child support. But here's the thing: you can legitimize the child and agree by consent to joint legal joint custody, and you do not have to do a parenting plan, and you do not have to
What does
do
that mean,
child
joint legal
support.
custody?
Custody. We have joint custody, equal 50-50 custody. We live in the same house, and we're not doing a parenting plan, and we're not doing child support. We're going to do joint custody without visitation and without child support. But now we do have the same legal rights to our child. The child is legitimized, and we have joint custody. And you can do that without a parenting plan, and you can do that without child support. And that is what I recommend for couples that are living together or still in a relationship together, but they're not ready for marriage, and the father is seeking to have joint custody of the child. It doesn't harm the mother in any way, but it does protect the father from not having any rights. In those situations where the father is not legitimized and does not have joint legal custody, you guys break up and she wants to move back to California with her family. There's literally nothing you can do. You don't have any rights to your child. Me and you have the same rights to your child. I don't know you or your child, but we have the same rights to a child that you have not legitimized and you do not have joint custody of. And so I try to express this 10,000 times over. If you want to protect your access to your child, you have to get them legitimized and you have to get joint custody. Whether you decide to go forward with a parenting plan, whether you decide to, go forward with child support, if you guys are still operating as a union making decisions for your child, that's fine. But the issue of legitimation continues to be one that evokes a lot of emotion. People are upset that the government is so involved in how they raise their children. The government is involved. It usually comes back around to the money, which is a whole other soapbox of craziness, because the person, and I'll be very clear when I say the person who physically has the child the majority of the time should get child support from the other parent. They should. And chances are, the majority of the time, we are not going to agree on what that amount is. So, like it or not, the government has implemented, especially in Georgia, a Georgia child support calculator. Put in your income, put in my income, and put in the expenses of the child, and it's going to tell you randomly some percentage of the non-custodial parents' percentage to pay to the custodial parent. So for simplicity, the mom and the dad, they're going to tell you how much child support you have to pay me to take care of the child. That money that you are paying, you don't get to tell me what to do with it. That money, I don't have to show you receipts of where I spent it directly on the child. Here's the shoes, here's the clothes, here's the soccer practice, here's the this, here's the that. That money is to help take care of the child's room and board. The child lives in this house. The child uses electricity, water, laundry detergent, tissue, soap, toothpaste. When I go to Chick-fil-A, I have to get my meal and this child a meal. I use more gas because I'm taking the child back and forth to their activities, to school, to the dentist. Like my water bill is more, it's 2 people. I need more dishes. Everything in the house that this child lives in is additional expenses. Your child support helps provide the room and board where the child lives at, and educational expenses like supplies and books and haircuts and all the intangibles when they go to a kid's birthday, a friend's birthday party, or something at school. Child support covers all of that. The cold they have in the middle of the year that they need Tylenol for. All of that. That's what child support is for. So no, there's no accounting needed, itemized accounting of what I spent child support on when you pay it. And I assure you, what you pay in child support is a fraction of what the custodial parent's obligation. We laugh all the time when I say, if we were to get a divorce, Charles, our son is living with you, and I will have the child support there. It is the easy job to just pay a check. But the person that's there every morning, if we were to look at this morning, today, wake him up, do the hygiene, go through the getting him ready for school, drive him to school, pack his bag, make sure he had breakfast, give him his medicine, lotion him up, so on and so forth, and drive him to school. He has swim today. Pick him up, change his clothes, feed him before he go to swim, take him to swim practice, bring him home. Then he takes a bath, and then we have homework, and then hang out with him, play with him a little bit, whatever, and then he goes to bed, and you wake up again and start all over again. And all you have to do is make a financial contribution. My entire day is directed around what time he leaves the house, what time I have to pick him up to take him to the next event. If all you're doing is making a financial contribution, consider yourself lucky.
I don't discount that it, but there are some fathers that want to participate in the getting them dressed, driving, the sick days, doctor's appointments, and all of those things. And there's parents on the other end that interfere with that and feel like they need to control the narrative on how much time they get with that. I understand that it may be 50-50, may not always be what's best for the child, but there still are fathers that want to participate in that, and they're not given the opportunity, or it's made difficult for them to do that. But at the end of the day, they need to legitimize their child and not wait till the last minute when child support papers are served to you that now you want to start to participate in that. So for the ones that handle it that way, I don't, that falls on deaf ears. Now for the other ones that isn't the case and they were involved, and you may have ran into a situation, I don't know everybody's situation, where you may have gotten locked up, or you may have got a restraining order on you to keep you away from the kids, so it made it difficult because the other party was doing that. There are those situations too. Now, again, that's a little bit different, but again, for the ones that, I got served with child support papers, now I want 50-50 custody, and I haven't been doing anything, and now I want to step in, I don't feel sad for you. But for the ones that are trying to be involved, that want to be there, that have been trying to be there, and the other parent is making it difficult for them, that's the part that's upsetting for me.
I feel like you're either going to be a victim or you're going to be a father, but you can't do both. If you want to be involved, then do. It's that simple.
It is. It's simple,
either
but it's
be
a
a
lot harder
victim or be a dad. Get an attorney, go to court, establish your rights, get a parenting plan in place. Because at the end of the day, the only person that chose that woman to be the mother of your child is you. So now if you have a child with some woman that's difficult, again, be more careful, because now you are a parent. And now that you're a parent, you're either going to be a parent or you're going to be a victim. And if you got a crazy baby mama, you can't use that for an excuse not to be there for your child. Get an attorney, go to court, get a parenting plan, and do the best you can with what you have.
Doing the best with what you have, agreed. For everybody, the easiest thing to go get an attorney, that they may not be in a financial position. And yes, there's some things that you can try to go without to be in that position. But
you don't have to have an attorney. You can if you qualify for legal aid, do that. If you have to put a little research into filling out the form on your own, there are a lot of fathers to do that. If you want to do it, you'll figure it out, and if not, you'll figure out an excuse that make you sleep well at night.
I'm not saying that they're figuring out an excuse. It's a lot easier when the child is with you, opposed to the one that's fighting the uphill battle. I'm not saying be a victim. You need to take some type of action, but it's an uphill climb. Period.
I don't think there's a period there.
You're not a man that was in that situation. So,
but you don't have to be a man to be in that situation.
You don't. But
you don't have to be a man to be in that situation.
The one I'm relating to are the men. I can't speak to the women that have been in that situation.
Well, I'm speaking to parents who need to be present and consistent from birth, and then your journey is a lot easier. It's a lot easier if you are present and you take action from the beginning. When you're deciding to start this journey, when this child is 4 or 5,
start it from day one. Agreed.
But you need to make a decision. You're either going to figure it out. It's too much information on the internet. It's too many help groups. It's just too many resources out here. So if you want to find an excuse and be a victim and, oh, woe is me, she's making it difficult and blah blah
I'm
blah.
not. I'm not saying
If
to be a
anybody want to
victim. I'm
do
saying
that, it's a
you need to
bag of
do something.
excuses.
To just talk about it and not do anything, that you're going to be in the same position. So you do need to do something and act on it. So to talk about it for 2 or 3 years, again, that's a victim. You need to put something in place, put some things in motion, regardless of what it looks like. Whether you do the research, you reach out to an attorney, you borrow the money, you drive Uber, you do what you need to do. But starting, you don't start, you'll never finish.
Again, that's legitimation in Georgia, whether you like it or not. A lot of people have a lot of comments. A lot of people have a lot of um, just questions and curiosity and fear, quite honestly, just fear of what that's going to look like for them. But we are here to help, whether it's we point you in the right direction, whether you retain our office, whether we send you some resources to assist you, whether you look at this podcast, TikTok, social media, wherever. We talk about this topic a lot because a lot of fathers have questions and they don't know what their rights are and they don't know how to maneuver the courts to get what you want. And my best advice is to get started as soon as possible when the baby is still a baby, before school and everything sets in, and establish your parenting time with that child. That's my advice.
Agreed. The getting started. I mean, the time of making excuses, that again, that falls on deaf ears. So you can talk about it and be sad and be the victim, but if you're not doing anything about it, then you might as well save everybody else's time and continue to be the victim. I I don't really have any kind words. You're either gonna be about it or not, and that's it. So I mean, my best piece of advice is start. You need to start and see it through. Whether you don't get the initial result that you want, you started it and you're still in a better place than you were yesterday.
Well, thank you guys for watching episode 23 of Love and Law, where we discuss legitimation and a lot of the fears and questions and concerns that a lot of parents have regarding legitimation in Georgia. Um, like, share, please share, and follow us for more information. If there's a topic you want to discuss, drop it in the comments, and we'd love to help dissolve and answer some of your questions and concerns.